Welcome to the Regulatory Transparency Project's 4th Branch podcast series. All expressions of opinion are those of the speaker.
Hi, and welcome to the Regulatory Transparency Project's 4th Branch podcast. My name is Steve Schaefer, and I'm the director of the Federalist Society's Regulatory Transparency Project. We are pleased to have with us today 2 stellar experts. Note, the opinions expressed are those of the experts and not the Federalist Society. First, we are happy to have with us Randel Johnson, distinguished immigration scholar at Cornell Law School. He has worked on employment and immigration law and policy for over 25 years, bringing a broad perspective from working in executive agencies, working on Capitol Hill, as well as in the private sector. We're also happy to have with us Andrew Kilberg, partner at Gibson, Dunn. He is a partner in the Washington, D.C. office, where he practices in the firm's litigation department. He has significant experience challenging regulations, advising on regulatory proposals, and defending agency enforcement actions and investigations. And both gentlemen speak in their personal capacity and not for their respective employers.
Well, thanks so much for that introduction. And this is Andrew Kilberg speaking, by the way. Randy, you've had 20 years in your career, over 20 years at the Chamber of Commerce. I think, about a decade on the Hill or more, a couple different stints at the Department of Labor, plus, a not insignificant amount of time at a major international law firm focusing on labor and employment issues. Here we're hoping to talk about immigration enforcement, particularly with respect to small businesses. And I think this is really a very timely topic with the new incoming administration obviously having understandably a huge focus on immigration, not just on border issues, I think here, but also as it impacts employment policy more broadly. So I was just hoping that in light of to start with your extensive experience in this area, I know you've been writing a lot about this too. Can you give a brief overview of what's driven you to look at this topic, in particular, how the system might be reformed?
Right. Well, thanks, Andrew. And I like to say I'm not the guy who can't keep a job. I'm more of a Renaissance man. So just for the record, but I did spend a lot of time on the Hill and at the Chamber, and frankly, my life was focused mostly on legislation on Capitol Hill, trying to pass a few pieces of good legislation, mostly trying to kill bad ones, and also laying the groundwork often for oversight on regulatory issues. For example, I was very much involved on ergonomics on Capitol Hill, and in fact, I ultimately, when I went down to the U.S. Chamber, co-chaired the National Coalition of Ergonomics, which used the Congressional Review Act for the first time to overturn a regulation, which was the Clinton-era ergonomics reg. So my life was focused on legislative and regulatory issues, but we did have oversight hearings, and we did have small businesses come up from time to time, whether it was NLRA or OSHA or EEOC. That was probably the big 3, wage and hour. And Andrew, it's when you're a staffer, relatively young, and you're sort of listening to people trying to run a business, and frankly, the government's gone in with an alleged violation, and these businesses are getting crushed by the government, not because of the allegations per se. I'm not saying there aren't any bad actors, but in this case, they just didn't have the resources to fight back. And then you see that how that it was a personal affront to them in terms of how they related to a government which they normally thought would have treated them fairly. And then they didn't have the access to use our vaunted judicial review system here, which is a fundamental aspect of the rule of law, because they didn't have the resources for it, and they couldn't put up the delay. They couldn't put up with the delays that it took to get a resolution through the system. So they gave up. And we had hearings on that, and I just said, this is not right. And then when I went down to the Chamber, we had a lot of big companies that are members, but we had a lot of small employers, and I would hear these sort of same stories anecdotally. And I just thought, this isn't America, frankly. And I know the old thing, but you can't beat City Hall. But we should be able to do something about this, which is these smaller businesses simply don't have the resources to defend themselves. And eventually I looked at it. We have something on the books called the Equal Access to Justice Act. And it's called Equal Access to Justice Act for a good reason, which is it was meant to help small entities take on government when they were innocent. And if they won their case, then ostensibly they were entitled to get their attorney's fees. But I think, as we'll talk about later, there's problems with how that act actually rolls out and the ability of employers and small entities, by the way. It's not just employers. The Equal Access to Justice Act was intended to help small individuals, small employers, small nonprofits. And so we had a lot of hearings on the Equal Access to Justice Act. And I used that knowledge when I went up to Cornell to work on immigration, and my portfolio was immigration. So I used that to write a paper on immigration and interview businesses and actual practitioners on how I-9 laws were enforced and the problems employers, again, had in defending themselves against government overreach.
So, and you can correct me because if I'm wrong, it's not my primary practice area in terms of immigration. But as most kind of new people who've applied to a job, gotten a new job, understand you fill out a form at the beginning and it says, this is who I am, or you hand over your passport or driver's license, whatever it might be, to prove that you are who you say you are. And my basic understanding then is that the employer has to complete the I-9 form, which is a way of verifying that the individual is not only legally in the country, but importantly, legally authorized to work in the country, not a tourist or some other person who's passing through here doesn't have authorization to work. So, I just wonder, can you tell me, correct any errors, but also who enforces this,
right,
and what are the pitfalls in there?
Yeah, and of course, people don't know, before 1986, you could work illegally for an employer, and then under Ronald Reagan, they changed the law, and for the first time, it was illegal for an unauthorized worker to work for an employer. It's illegal for the worker. It's also illegal for the employer to hire the workers. They enforced that through what is called the I-9 form, which you talked about, which is 4 pages, and if you look at it, you're like, oh, this doesn't look that hard. There's the manual that explains the I-9 system. I looked at it last night again. It's over 130 pages. The regulations are about 10 pages. There's multiple documents that a worker can proffer to the employer to show they're authorized. It's not passports is one, but and it's an ever-changing sort of list of authorizations. And then the form itself has multiple traps for employers to make mistakes on. But yes, that's the bottom line, is that you fill out the I-9 form. That shows that the employee is authorized to work. And hopefully the documents weren't fraudulent. They were reasonable on their face. The employer must accept the documents if they're reasonable on its face. And the employer may not ask for additional documents or ask too many questions of the applicant, because then they might be accused of discrimination based on national origin, which the law also provides back in 1986, a provision of non-discrimination, principally to protect Latinos. But that's enforced by the Department of Justice. So if you're an employer who asks too many questions or asks for a document that's not on this very complex list, you could be dragged into court or by the Department of Justice, because there is a private cause of action, by the way, on this also. And so, it's not as simple as it appears, like, oh, let's just fill out a simple I-9 form. But yes, that's the basic process. Validate that the person's authorized to work, but it's become a whole cottage industry now.
Mm-hmm. So, if I'm an employer and John Smith shows up at my doorstep, wants a job, I've got an ad wanted out, presents to me documents, they appear real, maybe I have access to E-Verify, I run them through, run the social security number, and it's there. I'm not allowed to do anything else as long as I fill out the form. But, because if I do, I might be subject to either a lawsuit from the Justice Department or from John Smith asserting that I violated his civil rights. But if I don't do any more, I might get a knock on the door from ICE saying, we know John Smith is illegal, and now we're going to investigate you for hiring an illegal immigrant.
Right. Yeah, and on E-Verify, just the I-9 documentation is separate from E-Verify, mm-hmm. and most employers don't use E-Verify. A lot of them do, but they're sort of separate, but the same type of issues. And Andrew, I have to note that it's no secret that there's going to be a ramp up of enforcement checks against employers under the new administration. I'm picking up this from a lot of practitioners who are certainly going to have a lot of billable hours in the future advising their clients on how to prepare their I-9s. But it's interesting. I was thinking that if you're an employer and you're like, oh my God, I'm going to be hit by a lot of raids or I-9 audits, and you start going back and looking at your books, if you look at them too carefully, again, you might run up against this catch-22 of like, oh, you're just going after Latinos now. You're just checking people that look Latino on your books instead of all the I-9. So employers have to be very, very careful on this, or they can be trapped either way.
Yeah, and look, this one could say, well, there's some leeway on enforcement from DOJ, but as you pointed out, there's a private cause of action, and we might all hope that the next administration stays in office for a long time, but elections are elections, and sometimes they go the other way. And with statutes of limitations the way they are, there's always some risk, down the road that you get hit with a lawsuit from DOJ that where control has been turned around.
Well, it's just you bring up statute of limitations because it's just a little niche, but there's a 5-year statute of limitations under both I-9 lawsuits for ICE, but also for the private cause of action in the non-discrimination area. I have no idea what it's 5 years, but I can tell you as a labor lawyer, as you know, Andrew, that's a very long time in our world. Usually it's 2 to 3 years, 3 years if it's willful under the FLSA. And so it's... There are a lot, but it's a world in which you could say you follow everything. But I guess my concern was what I heard from many employers was they really did do the best job they possibly could, and they thought they were in compliance. But there's so much discretion that enforcement officers have, and many times employers were threatened with debarment or criminal penalties over some XYZ technical violation, and the employer's like, I didn't really do anything that bad, and the compliance officer is, well, maybe it did, maybe it didn't, but you don't really want to be debarred, do you? So let's just settle this at X level. And as you know, debarment is the capital punishment for many employers. That's their lifeblood. And so they're forced into settlements, and many people would say, oh, that can't happen, Randy. They just go to court and appeal your rights and show the compliance officer was wrong. These employers can't take the time, and they don't have the money to go up the chain, which goes through an administrative law judge, justice, goes up to the district court, then the court of appeals, and then you might get a resolution.
Yeah, and so in debarment, of course, being for federal contractors, and that, often we think of the gigantic companies as federal contractors, but really is anyone who might be supplying groceries or cleaning services or whatever to, say, a military base somewhere in Kansas or wherever. There's thousands of American businesses that are federal contractors, large and small. You mentioned both the investigation and then, the ALJ process. The ALJs that's within DHS.
No, those are at Justice.
Okay.
Yeah, there's a special. It's got a complicated name. It's the Office of blah blah, but it's basically immigration courts in Justice.
But most cases, it seems like. I'm not sure if there's clear statistics on this, but it sounds like most cases probably don't ever get to an ALJ.
Well, this is an interesting area of what really happens, as I call it, the base of the pyramid in enforcement. People track legislation. You can track regulations through the Federal Register. What really happens at what I call the base of the pyramid of American laws, which is enforcement, has always been unclear. Because no one tracks that. It's very hard because everything is there's multiple cases, but each case is very individual. And so no one really tracks what goes on in those individual cases, much less how many. So the answer is, I'm sure you are right, because obviously we all know cases settle because people can't afford to go to court. That's why they settle. And it's interesting, even when we did the 1991 Civil Rights Act on Capitol Hill and tried to draw analogies to what was happening in California, we had to bring in practitioners to talk about what really happened at the ground level, because you can't look at this in a book and figure out what really happens when these laws are administered. And so when I did my paper, I didn't just look at the case law. I also interviewed practitioners and put that in the paper to get a grasp of what's really happening out there. Is that somewhat anecdotal? Yeah, it is. I can't talk to 1,000 practitioners, But I think it's consistent with my years of experience, 30 years in this area, talking to multiple people and hearings on Capitol Hill.
Yeah, from my experience as a former Department of Labor official and in private practice, so many of enforcement actions never actually get to the action part of what, the lawyers or law students listening think of as going to court, or whether that's a Article 3 court, Article 1 court, or a something less than some kind of administrative hearing. Most enforcement happens through investigation, and if there is a finding, through some kind of resolution with the agency, whether that's a settlement or an informal agreement with the Wage and Hour Division, whether that's a settlement, over an I-9 violation. It just seems to me that, if you could speak a little bit more, you talked about it a bit before, the kind of expense and time that goes into these types of small business immigration investigations at the investigation stage, way before it ever gets to an ALJ.
Well, let me say, when I talk to lawyers, it would be to take something up through the ALJ level. The estimates I got were 80 to 100,000. And then to court, the Ninth Circuit or whatever, of course, more. What happened below that? Again, there's a famous case called Fisher Holmes. It was written up in a book, by the way, and where frankly, under the Bush administration, Chertoff came in and raided this company, and that company was in 3 years of hell with the government just poking around, trying to find something. There was a lot of things going on Capitol Hill at the time, frankly, which was comprehensive immigration reform. And one of the theories was the government was actually trying to get employers to be more active on the Hill. And so they went after them in enforcement. But I can't prove that, but I can tell you it was likely true, so having been involved in that. And that company, as documented in the book, spent, hundreds of thousands of dollars just. But that guy could afford it. And he makes the point that the CEO of the company is interviewed in the book says, I could afford it, but I tell you, my supervisors who the government went after in alleging criminal allegations could not have done it had I not been able to back them up. If they had been a small employer or just an individual hung out to dry, they would be in jail. And so it's a lot of money. I can just put it that way without trying to quantify it. And what happens on the enforcement level before they go to court, again, this goes into, Andrew, a company knows it's going to be a laborious process. So they're like, screw it, let me just get out, let me settle, let me get this guy off my back and let him go over to the next guy.
Right.
And that's what we heard from, hearings on Capitol Hill and interviewing with practitioners. And that's not right. And that's why I went down this road of exploring why the Equal Access to Justice Act wasn't effective in helping these small employers.
And just before we get there, I think you mentioned before just how the I-9 form, it's short, but there's pitfalls in it. And if I understand correctly, there are violations for making errors on the forms too. This is not just where it's been investigated and determined that the worker in question actually was unauthorized to work. There can be a violation simply because the form wasn't filled out properly.
Well, completely. Or you didn't file it in the right place, or you didn't meet the 3-day limit. You didn't have the right type of receipt. And I looked at the regs again last night, and there's 4 pages of regs of sort of violations that aren't related to whether or not the worker is in fact unauthorized. But here's what one practitioner, who's actually a former Department of Justice guy, but let me just read this. To illustrate the impact of this enforcement philosophy, an employer may have a Form I-9 for all 2,000 employees, but somehow made clerical errors on half of the forms. These errors can be as innocent as failing to check a box or fill in a blank. The penalty for paperwork mistakes in this scenario can be as high as $2,000 per employee or per Form I-9. Therefore, even if all 2,000 employees are authorized to work in the U.S., this not-so-large company with a workforce of 2,000 can be liable for a $2 million fine just for not filling out the forms perfectly. And so this is a long-time practitioner out in the field, and I'm not making this stuff up out of whole cloth. And so that's again, that comes back to the form itself is 4 pages. The manual that explains it is 133 pages, and the regulations themselves are, just that section are probably 10 pages in the Code of Federal Regulations, which, as you know, are fine print and very complicated.
Three columns. When you talk about a page, you're really talking about 2 to 3 pages of normal text. I mean, what you're saying is it makes a lot of sense. You see discussion of this periodically on various agencies and in various circumstances about the ability to stack penalties. So you might just have one basic error. Say you have a HR director, you're a small to mid-sized business, one person always does the I-9s. They do it wrong every time in one little aspect. But if they do it wrong every time, to us in private practice or in businesses, we think, I'm making one error, but it's multiplied. And that's where your penalties can get jacked up. And that's where it's a leverage point for the government comes in and says, you did this 2,000 times. Say, well, no, I did it once. And they say, no, 2,000 times whatever, that's a lot of money. And that's a way of bringing businesses to the table for resolution when they say, I can't pay that.
Yeah, and I've seen this in other ways where a company hired an HR, they thought an outside expert, but this HR expert made the one error on one form, but then it was multiplied by every employee, which the regs is per employee or per person. And so, you're like, okay, in that case, well, in that case, that is what the reg says. And so it's not that the compliance officer in that case is going out beyond the regulations, which I would argue often happens also. But you got to just pay up. Again, and I think you combine that with these situations of as I've heard from practitioners in the case law is compliance officers trying to push novel legal theories or trying to use debarment or the threat of criminal penalties to leverage settlements. An employer can't hire a Gibson Dunn. Let's face it. Well, some can. Most can. But many can. And they're like, okay, just let me. What do you need? Let me just get out. Let me write a check, and the compliance officer then moves on.
Yeah, and so I want to get into the Equal Access to Justice Act. I know you're eager to discuss it. It's an important topic. To kind of roll into that, it seems to me what we're really ultimately, when it comes down to it, talking about is how do we balance the right incentives and disincentives? As I said at the beginning, I think everyone around this table recognizes that there's a big immigration problem. And that something needs to be done. The question is exactly how to approach it. There's a lot of employers, a lot of small employers and big, that want to do the right thing and are trying to do the right thing. And the government, there's a lot of very good agents out there and supervisors who are just trying to do their job to the best they can with really high workloads, lots of cases, trying to get through them. How does the Equal Access to Justice Act kind of work within those incentives? And I might interrupt, but the follow up is how could it be tweaked by Congress to better balance those incentives?
Yeah, and you reach a couple of good points in there. First of all, for I think for the listeners, because I've been, how should I say, disturbed. How many people I talk to have never heard of the Equal Access to Justice Act, which in fact tells you something about the fact it's not as used as perhaps as Congress intended. It was passed around in 1984, and it was intended as a way to help level the playing field between small entities and individuals and the government. And let me just one of the broadest and widest reaching federal statutes on the books to ensure that certain parties, particularly individuals and small businesses, are not coerced into complying with government actions simply because of the litigation expenses involved. It's meant to discourage the federal government from using its superior litigation resources unreasonably. It is in this respect an anti-bullying law. Close quotes. That isn't mine. That's out of a recent committee report. This is out of the Ninth Circuit. Enacting the EAJA, Congress stated, for many citizens, the cost of securing vindication of their rights and the inability to recover attorney's fees preclude resort to the adjudicatory process. preclude resort to the adjudicatory process, which most Americans think they have. When the cost of contesting a government order, for example, exceeds the amount at stake, a party has no realistic choice and no effective remedy. In these cases, it is more practical to endure an injustice than to contest it. This is America. It is, and this is the Ninth Circuit. In these cases, it is more practical to endure an injustice than to contest it. Why is that? That's because the much vaunted rule of law, which allows people to contest when they are abused by their government as citizens to use the judicial process, is more ephemeral than real because they can't afford it because of the costs and the delays. So EAJA, the purpose of EAJA was to try and address this. And it said that if you won your case against the government, again, an individual or a small business, you are entitled to your attorney's fees and costs in litigation, Andrew, unfortunately not in the investigative stage. So there's a limit. But it allows the government to still get off the hook if the government can show that its case was quote unquote substantially justified. And there's another called special circumstances, but substantially justified. And so the government loses. And then the employer says, oh, I'm entitled to my attorney's fees. And they're like, oh, no, we're substantially justified, even if we lost. So now the employer has to relitigate the case to show that the government was not substantially justified, which my evidence shows that the government normally routinely opposes because they don't want to admit they made a mistake, and for a lot of reasons, and they probably don't want to tell their boss they lost and have to pay the attorney's fees. And so again, I've heard from employers that say, we're not going to relitigate the case twice, we're just going to get out. And so one proposal is to eliminate that loophole of substantial justification. But to your other sort of point, I think here is, well, what's that do to the sort of broader enforcement regime? Well, I would argue it provides a good deterrent for the agencies to say, under this new EAJA amendment, we're exposed to attorney's fees if we lose. So let's slow down here and take a look at this case we're bringing against this small business or entity, and make sure we've got a good case before we bring the awesome power of government against this ex-employer. And I'm not saying your big clients, Andrew, wouldn't like the same thing to happen. I'm saying, though, there's a special case to be made for small businesses that government, I think, I spent 3 tours at the Department of Labor, should slow down and take a special look at should we bring the power of government against this person, and I think that would help target resources among the agencies to against more important cases. So it's not just about helping the employer, it's helping the government better target its resources, which, as you know, haven't been able to deal well also. Agencies always complain about not having enough resources. And then when I look at these cases that go up to the 11th or 5th Circuit with these crazy legal theories, I say, if they don't have any, if they're limited resources, why are they bringing these crazy cases? I mean, it's sort of counterintuitive, but I think these kind of changes under EAJA would help sort of better, frankly, target enforcement resources along with helping small employers.
Yeah, and do you think there'd be any, under your theory, would there be any trickle down to the investigation stage, or would this just prevent them from actually filing the action if the small business doesn't settle?
Well, I think well, first of all, to go down to the investigative stage, you'd have to amend the statute in another way plus. Mm-hmm. But I think it would trickle down in this way. I think the business or entity could say, well, this is crazy what they're doing investigating me, but I've heard about this new EAJA Equal Access to Justice Act bill is amended. So I'm going to fight these guys, and I'm not going to settle, and I'm going to move up through the system. I'm still taking a chance I'm going to win. But if I win, and I feel I'm going to win because I'm innocent, at least I've got a shot now of reimbursing my costs. So I think it'd be a trickle down, but not sort of a direct effect. I just want to real quickly, because I know I'm talking about employers, but there was a great case in the Ninth Circuit that a woman was on the no-fly zone, and she had to fight for 5 years to get off that no-fly zone. And it turned out she was on it only because a guy buried in DHS literally checked the wrong box on a form. And she had to fight that. Well, she had discovery to get it, and she got a law firm pro bono. And then the government fought the attorney's fees, even after they admitted it was a clerical error. And the Ninth Circuit went up to the Ninth Circuit like at least twice, maybe 3 times. And the Ninth Circuit finally said the government is engaged in scorched earth litigation, and we're going to give the attorney's fees to this law firm that protected this woman. But my point is, it took 5 years, and it had not been for EAJA, she would have been, out of luck, as many small entities would have been.
Well, one issue that probably wouldn't be solved, at least directly, by a legislative reform that you mentioned is you talk to people and they never heard of it. And, if the lawyers may have, but if someone's sitting out there thinking, oh, gosh, this is going to be expensive, what do I do? They don't even know that there's an opportunity to maybe get a lawyer and not have to pay in the end. How do we solve that? Just your time at the Chamber on the Hill, you probably have a better sense of the public education aspect of this than I do.
Yeah, well, I can tell you the plaintiff's bar is darn good about getting word out about new statutes and private causes of action.
True.
So if we were able to get these kinds of reforms done, I think groups like the Chamber, and particularly and NFIB in particular, because it represents small entities, would get the word out pretty quickly. And I think we would see a turnaround. Now, there is a cap on attorney's fees of $125 under EAJA. That's something that
$125 per hour.
$125 per hour.
Yeah.
And I think you probably bill a little higher than that. That would be also something that I would like to throw in the mix to correct, if possible, if we ever got this legislation moving. Unfortunately, lawyers are not the most popular people on Capitol Hill, so they're not the first victims you want to lead with in trying to achieve corrections.
Well, I mean, honestly, lawyers are probably the most popular in Washington, D.C. of any jurisdiction in the country. But that's neither here nor there. We were talking about this the other day, you and I, Randy, about, I think that another potential issue with EAJA is who pays the fees if there is a successful EAJA action. And my understanding from you is that it comes out of a fund in DOJ. Now, for the immigration area, that actually might work fine. DOJ's, doing the cases, or they're in front of a DOJ ALJ. But for other agencies, if we kind of zoom out a bit, maybe outside the immigration context, is there a mismatch in the incentive? If I'm a DOL or an HHS, if they have some kind of enforcement action, regardless of the agency, I'm just throwing out letters. Okay, they might say, well, yeah, that's not skin off my back. It's not my appropriations. Let the DOJ guys deal with that with Congress next session.
Yeah, no, it's another wrinkle. It kind of cuts both ways because when I was up on the Hill, we managed to get a bill that amended the National Labor Relations Act that provided the fix I was talking about, eliminating substantial justification, passed the House by one vote. But people were criticizing it because it would hurt the NLRB's ability to bring cases because it would have less money. Well, they wouldn't, because it would be coming out of the Justice Department fund. So in some ways, it undermines that argument about hurting enforcement. But to your point, yes, arguably less deterrence as it's not coming out of the agency's budget. But I would argue it still would be a not proud mark for the agency to have to be responsible for a lot of EAJA awards being awarded by DOJ or being paid for by DOJ, and therefore I would hope would still be a deterrent to the agency to bring these kind of cases. Would I prefer it come out of the agency's budget? I would. Having walked the halls of the Department of Labor, I think there's some excess money there to be used for these kinds of funds. But yeah, that is a sort of a sidebar agency. But you can see how I can argue both sides of it. Yeah.
Well, and I've lost my train of thought. I had an excellent point that I was going to pull off that, but I have missed it. One other thing you and I talked about, though, is also the statute of limitations. And I mentioned this before, but the government can sometimes take kind of aggressive positions on that. And how does that kind of roll into this, too?
The which one now? The
statute of limitations.
Oh, statute of limitations. Yeah, the 5 years. Well, well, there's two parts to that. One, because ironically, I've seen a report by attorneys out in the field that sometimes the compliance officers don't even know the proper statute of limitations. But when they do, they can use it as a weapon to say, look, we can go back 5 years on you. And I'm not even getting into continuing violations and all that there. We can go back 5 years of improperly I-9 forms. Why it's 5 years, I'm not sure. Maybe it would be, actually with the recent Supreme Court decision on posts or whatever it is, maybe it's more. But it's, again, I think that's an example of given the fact it's a 5-year look back, and I've seen, or as I discuss in my paper, situations of where compliance officers have not been fair. I think the 5-year statute of limitations exacerbates the concern about compliance officers having this kind of discretion to pressure employers into settlements by threats of debarment or criminal penalties, combined with the inability of the employer to go to court to vindicate their rights. I think it's almost like rubbing salt into the wounds.
And, I was just thinking through kind of other, setting aside EAJA, other types of reforms that maybe sometimes agencies themselves could impose to their processes, be kind of procedural rules that could fall within their authorities to just manage their own enforcement programs. And you and I talked about the other day one possibility of kind of mediation programs, an ombudsman that it would be ostensibly as neutral as an agency body could be, that's there for the sole purpose of trying to bring the agency and the business or the individual together to a resolution that's actually fair. Is that something that, we've seen this, we saw it, I think it was relatively successful at the Office of Federal Contract Compliance Programs under Craig Lean in the last in the first Trump administration. Is that something that ever could work in the immigration space? With respect to enforcement on businesses?
Yeah, in an ideal world, and I've tried this one successfully, I would hope an agency head, pick your choice, would actually voluntarily say, hey, I read this great paper by that Randy Johnson guy. Let's voluntarily get rid of this substantial loophole, and we'll pay the attorney's fees to small business and entities voluntarily. I did not get traction on that. But to your point, and if I was Secretary of Labor, head of DHS, particularly if I wasn't going to be called up for oversight hearings, I think a memorandum that says, which I have been, memorandum that says, look, we're not changing the law here. This isn't an APA issue. But let's just be conscious of the fact of how much power we have, and that small entities and small employers don't have the resources to fight back. So let's just be more careful. And to your point, let's if you're going to bring a case, let's assign a mediator to it, and maybe we can get it resolved quickly.
Yeah, and another example, again, from OFCCP in the Trump administration was self-limiting by evidentiary standards. And so this goes to your point, that's a different context. It's about, slightly different context in terms of race or sex-based discrimination or discrimination based on veteran status among federal contractors, basically kind of what the EEOC does for other private, the whole universe of private employers with who meet the statutory thresholds. But there it was saying, we have to make sure we have enough evidence before we go to a case, give the evidence, the basis for our allegations to the business in advance to try to promote resolution. It seems like there are lots of reforms that agencies could do, and with EAJA particularly to latch onto it, what do we think substantial justification is? And let's make sure that we're meeting that before we walk into the ALJ, before we walk into federal court, wherever it may be.
Yeah, before we start the initiation instead of on the after all that. Yeah,
sometime in the investigation stage, you have check-ins and you make sure that your case is proceeding and it's justifiable to spend the limited agency resources to continue it.
Yeah, and EAJA was a congressional determination that small entities are different than large entities, and they deserve a little bit of an extra hand up, I think. It's not, so the agency is not making this up. It's really a congressional sort of theory that's embodied in EAJA. And in fact, I'm glad that Chairwoman Fox, will probably not be the next chair of the Education Workforce Committee, but she has asked for a GAO report to look at this entire area. Because I'm not saying, there might be other reasons why there's so few EAJA cases filed, as demonstrated by the Administrative Conference. But she's asked for a GAO to look into this entire area. And so it's not just it's issue I'm looking at. I'm glad to see that the Congress is again, and maybe we'll get some traction out of that with the Republicans having kept the House and taken over the Senate.
Well, I think at least you and I agree that we'll miss Chairwoman Fox as the chair of that committee. I mean, just for such a long period of time, been such an advocate for fair and balanced enforcement and really clarity and guidance to employers and employees, both in terms of what the law is, not just what it should be. And she's been an excellent congressperson and really a chair of that committee. I remembered the point I was going to make, and this is the last thing I want to say before I think, ask you if there's any last words you want to give on this episode, is that inspector generals, it's kind of an inside baseball, really DC thing. And people who, if you're listening, you're not in DC, you might not ever really think about them. But to people in the agencies, they matter a lot. And they have pretty decent authorities and power to look into what's going on within an agency. Sometimes inside the Beltway, we hear news stories. Usually it's more about like a DOJ inspector general, something sexier like that. But they have them for if not all, most agencies, at least the departments. And that's, it seems that could be another way of looking at, particularly if there is EAJA reform, even without it, how are we... are there issues here with bringing cases that end up not being substantially justified?
Yeah, I guess that's a good point. IGs, I don't think I ever wanted that job when I was at the Department of Labor, but they're on a interesting string, and their authority is, despite I would say somewhat unclear. But I think that's a good point. That's something but it would have to come back. The directive would. No, I guess they could independently decide this is an area to look at. It wouldn't have to come down from the Secretary of Labor, whoever, and their efforts could certainly help supplement perhaps the GAO's study.
Yeah, something to think about. I mean, it's not they're not going to drive specific changes. They're not going to be out there educating people about EAJA and changing that system fundamentally. But just a thought about how this, in practical terms, might proceed if they're absent congressional action. So I don't know, Randy, is there anything that I didn't ask you or didn't hit on that you wanted to?
Well, I think I just did there on these two words, substantial justification. Yes, there's been Supreme Court cases on it. That doesn't mean it's clear what it means, because there's a great ILR piece out there that goes through a litany of hundreds of cases. If there's hundreds of cases, that doesn't mean it's clear. It means it continues to be litigated, and that gives you an idea of the kind of headwind that an employer would have to show that their case was that the government's case when they won was not substantially justified. And secondly, and it's a great read. I find it interesting. And secondly, the Administrative Conference of the United States recently started up again reviewing the use of EAJA awards under the agencies, and there's 4 years of reports out now. They were actually defunded for a while. Now they're back. I'm glad they are. That's a whole nother story. And the numbers of EAJA awards are just minuscule when compared to the portfolio of these agencies. So it's DHS, Department of Labor, EEOC, NLRB. And it also shows, Andrew, though, most of the awards that were made by the courts. Now, I'm talking about a small number of like 4 or 10, so it ain't a lot to begin with. But the point is that tells you the agencies, even those small numbers, fought them all the way to the courts because the courts had to step in and give the award, rather than the agencies saying, "Oh, we messed up, let's give the award." It's a little, I think, insight into how these agencies fight these sorts of awards, even if they lose. But the numbers, again, are minuscule, which I guess I'm a little biased based on what I've seen from many enforcement agencies. That's not because all these cases are non-contestable. It's because each is not working because the numbers are so small.
Well, look, it's going to be very interesting to watch, see how this all shakes out. As I said, I think everyone expects that there's going to be a lot of movement in the immigration enforcement space. We often, as consumers of mass media, think about the individuals crossing the border, but there's a lot of, there's going to be probably a lot of attention on the business side too, and it's going to be interesting to see how it all shakes out.
Yeah, it's going to be an interesting 4 years, and so Gibson Dunn may want to get into the immigration I-9 enforcement space. But
I can't speak to that. And again, I'll just remind everyone that all opinions expressed were mine and not the law firm's.
And mine are not Cornell's.
Well, I want to thank you, Randel, as well as you, Andrew, for this insightful conversation on this very important topic. And I want to thank the audience for tuning in for more content like this that involves the regulatory state and its impact on the American way of life. Please check out regproject.org. That's regproject.org. Thank you.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.